Hello friend, welcome to my YouTube channel NDS Shorthand. Please like, share and don't forget to subscribe the channel. Start. The question before us is whether the royalty levied by the impugned notification can be realized by the district council in respect of trees in private forests. Royalty, according to Jyotish Dictionary of English Law, means a payment reserved by the guarantor or a patent, lease of a mine or similar right, and payable proportionately to the use made of the right of the guarantee. In the true sense, what is sought to be recovered under the Act is not royalty, since the forest does not belong to the district council. The amount claimed by way of royalty under the notification is a compulsory extraction of money by a public authority for public purposes enforceable by law and is not a payment for services rendered. It is truly in the nature of a tax. In the High Court, various claims were put forward in support of the impugned levy. It was contended that the royalty in question came under clauses within bracket A and within bracket C of paragraph 8 within bracket 3 of the 6th schedule to the Constitution, namely taxes on profession, trades, callings, and employment, or taxes on the entry of goods into market for sale therein. It being neither of the two kinds of taxes referred to above, the High Court rightly rejected the above contention. It was next asked before the High Court that the levy came within the subparagraph 1 and 2 of the paragraph 8 of the 6th schedule to the Constitution, which authorize levy of tax on lands on the ground that the trees were growing on the land. The same contention is again pressed before us. We find it difficult to agree with the above submission, since if the levy is land revenue, then it should have been fixed in accordance with the principles for the time being followed by the government of the state in assessing lands for the purpose of land revenue in the state generally, as required by subparagraph 1 of the paragraph 8 of the 6th schedule to the Constitution. It cannot be sustained as any other kind of tax on land, since the royalty payable has no reference to the extent of the land and the nature of the land and its potentialities. It is a tax only on the timber which is brought from private forests. The notification in unambiguous terms says that the royalty shall be on the squared log pines. It has no reference to the land on which those trees have grown.